Okay, are we all ready now?
Yes, sir.
Any other questions about last week?
Hey, we're the ones who are here.
All right, just general survey. How many of you feel a little overwhelmed with the amount of information so far? You're right on track, because it is a lot of information that you have to know before you ever file a complaint. And that's another one of the things we have to consider this week before you file a complaint, is yet another one of those things you have to think about. Yes, ma'am.
As we're going through the weeks, I keep thinking about you saying that, I think you gave the percentage that 28 to 30% of this is bar tested. So can you give an example of like a question they may ask, whether it's essay or NDE?
Like a sample essay question? I just got that question over here this morning. All right.
Or even an NDE, just like a multiple choice. What are they really trying to... Yeah.
Well, in your bar review classes, they'll tell you the subjects that they want you to focus on, but let's give you an example about what a good essay answer would look like in here. Say that I've got a summons and complaint that I serve via UPS that's signed for by the mother-in-law, who happens to be staying for a month at the defendant's house. Everybody with me? The summons and complaint is sent via UPS, the overnight delivery letter, and it's signed for by the mother-in-law while she's there on vacation for a month. Now, y'all do know people stay for a month on vacations, right?
Your mother?
No, not mine.
Right.
All right, now, bless you. A good question might be whether or not there's good process in that case. So what would you think the issue would be if the question is whether or not there was good process? The issue is whether or not there's good process. That's not real difficult, is it? That's 1 point out of your 4 points on an essay. So what is good process? Give me a good general rule of what is good process.
It's a place of abode or competent. What is it? Not incompetent.
Procedures that have to be followed before you can take life, liberty, or property.
It has the name of the court.
Oh, that's a due process argument. I'm talking about process as in summons.
Like they're a good age and a good.
Legal serving of the person you're trying to serve.
If it notifies the defendant,
Like they can
How about this? Process in federal courts is good if it's served by a U.S. Marshal or designated agent, by a designated process server over 18 and not a party, or by any method acceptable under state law. That's a good general rule for process for federal courts. Now, the fact pattern I just gave you was UPS, wasn't it? Tell me whether or not UPS is either a U.S. Marshal, a designated person, or anybody over 18 and not a party.
Yes, over 18 and not a party.
Ah, UPS is a person, huh?
Yeah. Right.
Is UPS a person?
No.
So is it good process or not?
no.
Guess not.
It's not.
Wow.
Now, is there good service process? That might be the next question. The next question is whether or not there's good service of process.
What was the first answer?
What was the process? Was it good process?
Is it a U.S. Marshal? No. Is it somebody over 18 and not a party?
Yes.
No, it's UPS, right? That's not a person.
But how could the
Over 18 and not a party.
But the driver is a person.
But the driver doesn't sign a return on service back. They fill out the UPS paperwork.
Gotcha.
Okay.
So over 18 and not a party means you got to fill it out that says I personally served. They don't do that.
That makes sense.
You got it? And then is it somebody who's designated specifically by the court?
No.
And then for exam purposes, we're not going to test you on all the different methods under state law in Alabama. However, is it good even under Alabama state law?
No.
No, it's not even good under Alabama state law either. So do you have good process in this case? And the answer is no. The conclusion is you do not have good process in this case. Or process was not proper. Question number 2. Whether or not there was good service of process. That's question number 2. Whether or not there was good service of process. What's the issue? Whether there was good service of process. Hello? Most of the time the question is going to be what your issue is, right? Unless I give you one of those identify and discuss all issues.
Yeah, please don't do that.
Oh, I do that all the time. In fact, that's the best way for me to test whether or not you know what it is, because that tests you on your issue spotting instead of me asking you a specific question about an issue. All right, so whether or not there's good service of process. What is a good general rule for service of process? Oh, come on, folks. This was week number 4.
U.S. Marshal.
Week number 4. Service of process is proper if it's personally delivered to the individual that's being sued, or if it's left at their residence or usual place of abode with a person of suitable age and discretion residing there. That's a federal word, right? Or if it's served on their agent. That's the general rule for service of process. Isn't that what y'all have in your notes that you turned in? Isn't that what you need to study for your general rule of law? And it's in your own words, right? So, if I left it with the mother-in-law who's visiting for a month on vacation, is that a person that I'm suing directly? No. Is it a person of suitable age and discretion that resides there? No. She's just on vacation. She doesn't reside there. Remember, reside is your intent to permanently stay somewhere, right?
They have a vacation home.
Then is that their usual place of abode or residence? But this is delivered to the defendant's home, but delivered to the mother-in-law. So is that good service of process for the mother-in-law? No. And then is it to their designated agent? You're guessing at that, right?
No.
I didn't tell you whether or not she was her registered agent or not. So you can say in your conclusion it's good service if the mother-in-law happens to be her registered agent. Otherwise, it's not good service of process. That way you get around jumping to conclusions on facts that you just don't have enough information on. You see what we did on that answer? You don't assume facts. You work your answer around the facts that you were given. Now, if I come back to you and say, delivered to the mother-in-law who's not a registered agent, or not an agent for service, then you can specify the facts say she wasn't the agent, so it's not good service or process. Now, that would be the conclusion, right? Everybody with me? It's a simple 4-sentence analysis for whether or not there's good service or process. And the other example I gave you is good process. Everybody got that? This is a whole lot easier than contracts. But you wouldn't have known whether or not process was good unless we spent a week talking about process and who you have to serve, or who has to serve it, and then process itself being the actual summons. Now, if I give you a fact pattern that says, the only thing that was delivered with a copy of the complaint was a letter saying you better answer this or I'm going to get a judgment against you, is that good process as well? No, because it says you have to have directed to the defendant and warn them if they don't answer that, they're going to have a default. Remember the rule? Rule 4?
It's a substantive.
It's a substantive argument about process rather than a procedural. That's absolutely correct. Substantive. It didn't have the required statements in it. The letter did not. Not to mention it wasn't signed by the clerk of court, right? You got a whole bunch of different reasons why it's not good. All right, so does that answer somebody's question on, I guess, the essays? Somebody asked about essays over here. I know this front table asked about this morning before we started. It does not have to be complicated.
What about an MBE?
An MBE, I could sit here and probably come up with a question that where two of the answers are right and just twist you on which one's better, but I can't think that fast. I got to go pull one of my old questions and give it to you. How about this? A plaintiff, a non-resident defendant plaintiff is served out of state. Now let's do this. A resident defendant was served out of state. And they filed an answer without objecting to personal jurisdiction.
It's done. They waited.
Which answer is better? Or which one is the stronger argument on personal jurisdiction? Sufficient minimum contacts. Is that a good one?
Say that again.
Sufficient minimum contacts.
Or
Or they're a resident and it doesn't matter where they're served. Ooh, that's right, isn't it? Or they voluntarily consented to the jurisdiction by failing to raise a personal jurisdiction.
I'll go with that.
That's your list of 6, right? Which one is the stronger argument?
The last one.
The last one.
So see, there's your multiple choice one where it's got actually at least 2 right answers. But then you pick the better of the answers. Does that help?
I mean, you didn't give a fourth one, so I'm kind of nervous.
All of the above.
Oh, no.
How about that? That one's probably right too, isn't it? But it's not the best one.
Could you repeat the last number 3 answers?
All of the above.
No, the last.
They waited.
Oh, they filed an answer without raising an objection.
All above would have been better.
Well, all the above is actually correct, but it's not the best argument, or it's not the best answer.
You have to do less work with the others to try to prove all.
And that's why it's the best answer. Because if they waive it, they can't have any argument as to why they don't have personal jurisdiction, right? That list of 6 that we put up there on week 5, after we summarized all the U.S. Supreme Court cases from 200 years.
Let me just ask you one more question. So, what if they maybe filed a motion to strike their answer in order to try to kind of clean it up after you?
Who files a motion to strike?
The defendant who already filed an answer.
Oh, well,
What if they try to go back and clean it up and say, oh, I forgot to raise the jurisdiction issue in my answer, so I'm going to try to...
they just need to call their malpractice carrier.
It's over. Okay.
Yeah, because they failed to raise it, right? All right, any other questions about last week? Last week is pleadings and parties, right? Compulsory counterclaims and permissive counterclaims. Cross claims, you don't have to actually issue a summons because they're already a party. And then third-party claims, you have to issue a summons because they're not a party. And that's under third-party practice, which is Rule 14. Counterclaims and cross-claims are 13. Remember the real party in interest? Who was actually damaged versus standing, which is who has the right to bring the cause of action. And for a child who's injured, who has the right? Their parent or guardian or caretaker. And for somebody who's incompetent, who has the right to bring the action? Their guardian if they have a court-ordered guardian, or else their caretaker. And in civil practice, we usually call it their next friend, which means somebody that really doesn't have the legal right to, but they're doing it on behalf of the individual. All right, anything else? That's last week. Now, I started off with a question about how many of you feel like it's overwhelming information. And I think everybody but one raised their hand. Who was the one that didn't? All right, well, if there's one class this semester that you don't want to miss, it's next week. Because hopefully, it'll all come into focus next week. As to why you're learning all these different things. Because these are things you have to actually think about before you file a complaint. And the next one you have to think about before you file a complaint, which is this week's subject, is something called venue. Under 28 U.S.C. section 1390, as soon as I find 1390, Congress actually defined what venue is. So here's the definition of venue. It's under 1390, Part A, as used in this chapter, which is the chapter on jurisdiction and venue for the federal courts. The term venue refers to the geographic specification of the proper court or courts for the litigation of the civil action that is within the subject matter jurisdiction of the courts, the district courts in general, and it does not refer to any grant or restriction of subject matter jurisdiction, providing for civil action to be adjudicated only in the district court of a particular district or district or districts. Out of that big definition, you'll know what really matters as far as venue. It's the geographic location of the court. And the rest of that says the geographic location of the court does not affect subject matter jurisdiction. Well, let's go back to week number 2 of our lectures, the subject matter jurisdiction of federal courts. What is the test for subject matter jurisdiction of the federal trial courts? Federal question.
Diversity.
Or diversity, or what else? That's part of diversity.
Was it 1367?
1367, which is supplemental jurisdiction. So as long as you've got a claim that gets you in, remember last week we talked about that form complaint? As long as claim 1 has either federal question or diversity, claim 2 can be, and claim 3 and 4 and 5 and 6 can all be supplemental because the court already has jurisdiction to hear one of your other claims, pursuant to either federal question or diversity. So you can invoke separate jurisdictions, diversity being the easiest because you only have to prove, if it's federal question, you only have to prove one cause of action arises under a federal law, Constitution, treaty, or statute of the United States. Simple. Diversity, you have to prove 2 different states and more than $75,000. Why do you want to prove that another time? Just say, Judge, we've already proven jurisdiction for one claim. Just throw all these else under supplemental because once you've got the jurisdiction to hear one, you got jurisdiction to hear them all. In fact, Rule 18 says you can bring as many different claims as you want, right? Y'all remember Rule 18 last week? And Rule 20, as many different parties as you want. As long as you bring at least the ones that are required for just adjudication, which is Rule 19. And you don't misjoin or non-join some, which is 21. So, venue is defined as the geographic specification of the proper court or courts for litigation. That's kind of simple, isn't it? And what's the definition of venue say? It's the proper court, right? So what do you think happens if you file a complaint in an improper court?
It's tossed.
Bless you.
Yeah, it gets
Kicked
tossed.
out.
Or you can agree. And you can just change it.
It's 1404. Here it is, 1406A. Says the district court of a district in which is filed a case laying venue in the wrong division or district. Now remember when we talked about the federal courts, we talked about 3 districts in Alabama, the northern, the middle, and the southern. And then when we looked at the northern, I think it was section 81 defining Alabama, the northern district had 7 different divisions in it, didn't it? So this statute says the district court of a district in which is filed a case laying venue in the wrong division or district shall dismiss. Or, if it be in the interest of justice, transfer such case to any district in which it could have been brought. So what's Congress's initial mandate for a case that a plaintiff can't pick the right venue?
It's tossed.
Dismiss it. That's your next bouncer. Remember we talked about the bouncers at federal court? Bouncer number 1, subject matter jurisdiction. There's a presumption against federal courts having jurisdiction. But once you can show them that they do, either by federal question or diversity, and then any other claims can be supplemental, once you show them that they do, then they have that virtually unflagging obligation to hear your case, unless they don't want to because of abstention doctrines. Colorado River being probably the easiest one. They just don't want to exercise judicial resources on your case. So they have the obligation to hear it if there's subject matter jurisdiction, but you got bouncer number 1 at the door, that subject matter jurisdiction is going to bounce your case if you don't get it in the proper jurisdiction. What's the next bouncer we talked about? Serving it within 90 days, right? You can't get the defendant served in 90 days, that bouncer is going to throw you out. Well, now there's another bouncer that's venue. If you can't file it in the wrong venue, Congress's initial mandate is to throw it out. And then last week we talked about another bouncer, stating a claim upon which relief can be granted. If you can't meet that heightened pleading standard of Twombly and Iqbal, which is plausible claims, not just notice, but plausible, they're going to throw you out. Now, how many of you still think federal court is friendly to plaintiffs?
When they revised it to offer the option of transfer to the appropriate court.
Let's talk about transfers to courts. Can a Detroit, Michigan judge transfer a case down to Alabama court?
Don't you have to petition it?
All right, well, let me ask you this. Does the Michigan court have jurisdiction over the Alabama courts? Does the Michigan Supreme Court have jurisdiction over the Alabama trial courts? Why not? They're separate governments, right? So can you literally transfer a case down to Alabama?
You have to have an action.
You'd have to have another avenue.
Now, the judge can say, I'm going to dismiss this so you can refile in Alabama, but you got to file a case in Alabama. You don't just simply transfer a case from Michigan to Alabama.
But if it's within Alabama.
If it's within Alabama, then they can transfer it anywhere inside the state. But across state lines, they don't do that in state courts. Now, in federal courts, where all the courts are part of a single federal government system, can they transfer a case from a federal court in Michigan down to a federal court in Alabama? Yes, because it's still part of the old same system, right? So you got to keep that sovereignty in mind that if you're in a state court somewhere else and you're going to try to cross state lines, they don't have any jurisdiction. Remember, we talked about Alabama. It's coextensive with the state. It means it goes to the state line boundary, and that's as far as it goes. It does not extend all the way to Michigan. So, 1406, the district court shall dismiss it if it's in the wrong venue, or transfer it to one that would have been proper to start with. So now you need to know, what is a proper venue for federal court? And I want to give you a couple cases. This one is Central Trust versus McGeorge. And this is a U.S. Supreme Court case. Here's what the court said. The act of Congress prescribing the place where a person may be sued is not one affecting general jurisdiction of the courts. It doesn't affect whether or not it's a federal question or diversity, does it? The proper location, geographic location for a court has nothing to do with subject matter jurisdiction or even personal jurisdiction, does it? They go on further, it says, it is rather in the nature of a personal exemption in favor of the defendant, and it is one in which he may waive. Now, what does that tell you about venue? If you fail to raise it, it's what? It's waived. Venue is waivable. So is personal jurisdiction. We found that out week 5, right? With all of our cases. That if you fail to raise it, it's waived. The only one that's not waivable is subject matter jurisdiction. And then they say, if the citizenship of the parties is sufficient, the defendant may consent to be sued anywhere he pleases. And certainly jurisdiction will not be ousted because he has consented to being sued in a venue. By the way, that was as early as 1894 where the Supreme Court said, oh yeah, venue's waivable. And now here's one of the more entertaining cases. This is Stewart Organization versus Rico Corporation. And how many of y'all know where Stewart Corporation is? All right, how many of y'all drive in on 2059 to come to class from the east side? As you're driving past the airport, you see a big building out there that says Stewart Organization?
Yes,
Stewart. In this case, it's an Alabama copy machine dealer who is the Stewart Organization. Now they're located out in Homewood. Against a New York manufacturer, which is Rico Corporation. So it's Stewart versus Rico. And the Stewart Organization brought a diversity action. Listen carefully. A diversity action against the manufacturer alleging breach of contract, breach of warranty, fraud, and federal antitrust violations. They brought a diversity case for federal antitrust. Are y'all seeing something? Yeah, it should have been a federal question, right? But they brought it as diversity. And why did they do that? Well, the plaintiff is the master of his complaint, right? They get to choose whatever jurisdiction they want to invoke. Now, generally speaking, why do you invoke diversity jurisdiction? There are different states in federal court, and it's more than $75,000, but why do you invoke diversity jurisdiction?
To encourage them to settle it because it's for travel and expenses.
All right, what law applies on diversity case?
Doing business.
Is that what Erie Doctrine is? State law applies, right? Erie Doctrine is state law applies in federal cases. So now they have filed in federal court a federal antitrust case, and they're trying to make the courts use state law because they invoke diversity. instead of using federal law. Y'all see what they did? It seems kind of counterintuitive, doesn't it? Now, you want to know why they invoked diversity? Because Alabama's venue statutes are different than federal venue statutes. And because they had agreed under their contract to sue in federal court up in New York, but they wanted to have their case tried down here in Alabama, they invoked diversity so that Alabama law would apply instead of federal question, where federal law would apply, and it should have been filed up in New York. So they were trying to force it to be tried in Alabama. It's not a bad little trick they tried, is it?
Did it work?
Was it successful?
Well, the case went all the way up to the U.S. Supreme Court, and they actually granted certiorari on it. And the question is this: on an Erie Doctrine case, what state law actually applies in Erie Doctrine cases?
That's
State law, but what kind of state law?
state, the law in that state.
Okay, let's rephrase it. What rules of procedure apply in state courts? The Alabama Rules of Civil Procedure. What rules apply to procedure in federal courts? The Federal Rules of Civil Procedure. Now, those apply regardless of whether it's diversity or federal question, right? Because the rules have nothing to do with the substance of the law. They're the procedural part of the law. Everybody see where we're going? Now, by invoking diversity, they were trying to get the venue statutes in Alabama to apply instead of federal venue statutes. Now, are the venue statutes procedural or are they substantive? That's what the U.S. Supreme Court had to take up in this case. And the Supreme Court said it's procedural. And because it's procedural, we're still going to use the federal venue statute because it's federal court. Congress gets to say what the venue is for federal courts, just like they say what subject matter jurisdiction is. And so it's only substantive law under Erie, which actually applies in federal court when you sue under diversity. All the procedural, including venue, is all federal. So you have federal subject matter jurisdiction, federal procedure, and federal venue in federal courts. Now, is that kind of cleared up for everybody? If you're going to sue in federal court, you got to use federal rules. But if you invoke diversity, then you use state substantive law only. You don't use state other laws like venue, because when you pick federal court, you pick federal venue to go with it. Yes, ma'am.
So when they had a contract that said that they would file in New York, why wouldn't they have decided to file two separate suits?
Because New York law was not as favorable to them as Alabama law. In fact, the opinion says the agreement contained a clause providing that any dispute arising out of the contract could be brought only in a court located in Manhattan in New York City. Yes,
So
ma'am.
when they sent this back down to, it was under Rule 1404, and they sent it back down to Northern District of Alabama, what happened when they made them answer the question of whether or not it needed to be tried in Manhattan? I don't see the
Well, I'll give you a quick pointer on that. You remember our Keaton versus Hustler magazine case? What did Keaton do in that case? She waited too long, right? And the only court that she had that she could sue in was New Hampshire or wherever it was up north, because that's the only statute of limitation that didn't run. So she voluntarily submitted herself to that court and then was able to prove sufficient minimum contacts for the defendant to keep him in court there. Now, in another case that you're going to cover in your conflicts of law, you're going to run across the fact pattern that's kind of similar to this, if not exact. There was a couple that had a car wreck in Mississippi. So all the evidence, all the witnesses were in Mississippi. But they missed the Mississippi statute of limitations. So they filed it up in, I think it was Pennsylvania, where they still had a live cause of action. And then, because of venue, in fact, specifically what we're going to cover tonight, or today, about where it would be more convenient for the parties, after they filed the case up in Pennsylvania in federal court, they filed a motion to transfer venue back down to Mississippi for them to try their case, because all the witnesses and all the evidence was down in Mississippi. You see what they did? Why didn't they file it in Mississippi to start with? Statute of limitations had expired under Mississippi law. And it was diversity because it was somebody from out of state. And they were from Mississippi, I think. I knew it was diversity. So they filed up in Pennsylvania, and then a motion to transfer it back down to Mississippi. So what law actually did they apply in the Mississippi courts to her case? What substantive law did they apply?
Mississippi.
They applied Pennsylvania law because that's where she originally filed the complaint, even though it was transferred back down to Mississippi. So the statute of limitations had not expired, but it was going to be tried under Pennsylvania law rather than Mississippi law.
So why is that not forum shopping?
It is.
Oh, okay.
So they get away with it?
Yeah. Yeah. That's my recollection. They got away with it.
Were the people from Pennsylvania? How did they?
No, they just ran out of time, and so they filed.
But how was it?
They just
The minimum contest. I mean,
Well, they didn't have to argue minimum contacts up there when they had to transfer it back down to Mississippi. Right?
But you had filed it federally.
So, what you learn about venue, you're going to see it again when you get to conflicts of law. And know that it's one of the things you have to consider before you file the complaint, because Congress's initial mandate in 1406 is to dismiss your case if you can't pick the proper venue. And what are they going to do if you can't pick the proper subject matter jurisdiction? They're going to throw it out. What happens if you pick a jurisdiction where you can't get service within 90 days? They're going to throw it out. What happens if you pick a jurisdiction where you can't state a plausible claim? They're going to throw it out. Everybody with me? Yeah, all the bouncers. Yes, ma'am.
In the Mississippi case, how did they, I understand they went to Pennsylvania because of the SOL, but why, what was the relationship?
SOL is in statute of limitations and not out of luck.
What was the relationship that allowed them to even file in Pennsylvania?
Under what authority? They paid the filing fee.
That's all.
That's it.
So there doesn't need to be a resident of the state or some type of tire manufacturer, you know.
They argued around it.
They argued around it.
Uh-huh.
So federal venue seems like convenience.
Yeah, they argued for more convenience in federal court. So what you need to know, somebody's getting a phone call. Ms. Ergus Rogers, is that you?
Somebody get you what?
Phone call.
PA system. Yeah, it's over there.
Okay. Now, you're probably wondering, since you already know that they're going to throw your case out if you don't have proper venue, how do you determine what proper venue is in federal court? And the answer is, it depends. As with everything else, it's always an it depends. So there's another general concept of law that you need to understand. And that is, when there are two sets of laws passed, and one of them is a general law, and the other one is a specific law, which one do you think applies? Which one do you think overrules the other? Specific overrules the general if the circumstances for specific are met. Okay? Now, we have a general venue statute, and it's 1391. And this is the federal court's venue generally. 1391. Yes, sir. Mr. Gray, I know you're dying to ask a question. No?
I have a question.
Mr. Francis, what?
Backing up just a little bit. You said substantive law. Make believe we were in that case, like the Pennsylvania, Mississippi thing, and you want to get creative in the case. Do you need, that was kind of a creative case, or was it just, do they have to get, I'm sure they have to
I think
get
it was just a
permission
car
from the
wreck.
judge. They have to go by all these rules. Are they going by federal rules? Are they going by state rules? How do you do that if I'm in court right now and I'm trying to do it?
Well, you use all the procedural rules for the court that you're in. So if it's the rules of procedure and you're in federal court, use the federal rules of civil procedure. And then venue, according to Rico v. Stewart, or Stewart v. Rico, venue is procedural in nature. So you use the venue statutes in federal court when you're in federal court. The venue statutes for federal court when you are in federal court. Now, the substantive law would be, as an example, Pennsylvania definition of negligence. What do you have to prove for a Pennsylvania negligence case? And you go to Pennsylvania's jury instructions and you go to Pennsylvania's case law to see what you have to prove for a negligence case in Pennsylvania.
Do I need to make a motion? Do I have to ask the judge?
Nope. Judge automatically applies that law. And then if they don't, there's Rule 44.1 that you can tell the judge, this is the law that applies in this case because I filed it under diversity and we use the law of the state where the court is located in a diversity case for substantive law. But I wasn't going to get to 44.1 till next semester. All you need to know now is Erie doctrine, and that Erie applies to substantive law only, not procedural. Procedural is the rules, the evidence, and also venue. Okay, let's talk about the general definition of venue. There's three circumstances that you test for venue statutes in federal court. Number one is you get to pick the federal district of any defendant's residence if all of the defendants are residents of the same state. That's test number one. Remember apples and oranges and peaches and pears and all those different tests we have? This is a separate test. You get to pick any district in which any defendant resides if all the defendants reside in the same state.
And wouldn't it be the same district for all the same states?
How many districts does Alabama have?
I have a northern district of Alabama.
We have three. Northern, middle, and southern. In fact, I'll give you a couple of examples to walk you through that so we understand exactly what that means. If I have a Georgia resident who wants to sue an Alabama defendant, and the Alabama defendant resides in the Northern District of Alabama, okay? So I've got diversity, and I'm going to assume it's more than $75,000. So we're not questioning subject matter jurisdiction. All we're looking at is venue. There's one defendant, and that one defendant lives in the Northern District of Alabama. My first question is, what districts are available? Northern District. And do all the defendants reside in the same state? I've got one defendant, right? All of him resides in the same state. So what's the proper district to file it in Alabama if he resides in the Northern District? Only in the Northern District. You file it in the district in which any defendant resides if they all reside in the same state. All right, let's go to two defendants. You see what we're doing?
Yeah.
Now in this example, it's again a Georgia resident, so diversity, and it's more than $75,000, but this time I've got two Alabama residents that are being sued. One is in the Northern District of Alabama, and the other one resides in the Middle District of Alabama. So what are the proper venues for our Georgia resident to file suit? Either northern or middle, because you get to pick any district in which a defendant resides if they all reside in the same state. Question number one, do both defendants reside in the state of Alabama? Yes. One in the northern, one in the middle. So which district is proper? The northern or the middle? Now what happens if I pick the southern district of Alabama?
It's gonna be dismissed.
Judge's mandate is to dismiss the case, right? Or transfer it if it's in the interest of justice. But the first mandate is to dismiss.
What does it mean by the interest of justice? Like,
Whatever you can convince the judge.
oh, okay.
They haven't defined that term. All right, now, third example. What if I've got a Georgia plaintiff suing 3 Alabama defendants? One Alabama defendant resides in the northern, one in the middle, and one in the southern. I've got 3 proper venues, right? The northern, the middle, and the southern. So which one do I have to pick? Any one of those 3. And as long as I pick one of those 3, it's proper because I have a defendant that lives in one of those districts and all 3 of them reside in the same state.
Could he also assert or file in Georgia because he lives in Georgia?
We're getting there.
Okay.
Yes.
Alabama's, I mean, it's geographically obviously far north south, but not compared to other states. But could a judge within the state move it to a more central location if he had going west and east Texas versus, instead of one street to the other?
If everybody agrees to it, yes. And we're getting there. That's one of our venue rules. All right, speaking of, I think it's tomorrow we have to start dialing 10-digit phone numbers.
Yes, I remember the news this morning.
Yeah, go through your phones because Alabama's got a new area code 659, I think. That starts tomorrow. So if you've got the law school's number in your phone, it's simply 322-6122. Go in and edit it, put a 205 in front of it now because it won't work starting tomorrow.
For 10 years anyway.
It's been like that forever in Chicago because Chicago has overlaid area codes, but Alabama now is about to have an overlay. Their number is still going to be 205, but all the new telephone numbers are going to be 659s. Nope, all the 205 area codes. Just 205 is overlaid. All right, test number 2. Test number 2, if it doesn't fall into number 1, here is the test that you use. Now, why wouldn't it fall into number 1? Because you have defendants that live in other states, right? So, test number 2 is this. You file it in any judicial district in which a substantial part of the events or omissions giving rise to the claim occurred, or a substantial part of the property that is subject to the action is situated. In the district where the act or omission occurred, or the district in which a substantial part of the property which is subject to the litigation is located. Wherever the property is located. All right, let me give you an example about where the property is located. Let's assume I've got a piece of property that spans both Shelby County and Chilton County, okay? Now, Chilton County is the northernmost county of the Middle District of Alabama. Shelby County is the southernmost county for the Northern District of Alabama. So the federal courts cut off at those county lines between Shelby and Chilton. All right, everybody follow that. Now, what if I've got an Alabama an Alabama plaintiff who owns property in a portion of Shelby and Chilton County, and they're suing somebody from out of state, and it's more than $75,000. So now we know it's going to be diversity. And they're suing two people. One is a resident of Georgia, and one of them is a resident of South Carolina. Neither one of those are Alabama, so our Alabama resident has got two different states, right? So it passes past that first test because not all the defendants are in the same state. Does everybody see that? Okay, now, he's suing to see who the owner is for a piece of property. And the problem is, 50 of those acres in the parcel of 100 acres, 50 of those are in Chilton County, and the other 50 are in Shelby County.
Would it be where he lives?
Oh, so it would still,
Now, they're suing over the piece of property as to who owns it.
He had to file the county where he lived, or in the district where he
He's
lives.
got to pay property taxes in two counties because it's in two different counties.
So they filed paperwork.
so
Is that what the statute says?
Substantial portion of
Most of it.
Listen carefully to what this venue statute says. It says, in a judicial district, or a substantial part of the property that is subject to the action is situated. So we're already talking about title of the property. And there's 50 acres in Shelby and 50 in Chilton.
Which side of the
So either
He can file an
Either one is right.
Right.
Because there is a substantial portion in either one. I'm trying to get y'all to see that. Because it splits through the middle in two different districts, you can do it in the northern district, which includes Shelby, or you can do it in the middle district, which includes Chilton. Because there's 50 acres on each side. Now, what if it's 75 acres in Shelby, 25 acres in Chilton?
It's called the Northern District because that's where.
Let's say 25 acres is still substantial.
You say 25 acres is still substantial, wouldn't you?
No,
Is it?
not
Yeah.
And what if it's where the house is
That's
located?
what I was, where the house
If the
is.
house is located, then you have to file it in there.
All right, let's make it even easier. What if 99 acres are in Shelby and 1 acre is in Chilton? Clearly, we'd agree Northern District because 1 acre is not substantial when you talk about 100 acres.
There was 75, or there was 25 when you talking about 100.
Well, I think that's an it depends, isn't it?
What if there's a
I'm gonna
property
put that on
value?
your test.
Oh, there is a property value difference.
I mean, like, even if it was 50. Well, a real estate appraiser can tell you which is the biggest value.
Yeah, the property in Shelby County is going to be worth a whole lot more than Chilton County, unless you happen to have a peach farm on it.
So then it would just be, if you were on the other side of that, or if you were trying to say, I want the 25 versus the 75, then you make this is what substantial means to me.
There it
in this
is.
instance.
And what are the words for that? It depends, right? It depends on what substantial means and whatever you want to argue to the judge. And you can argue to the judge, I filed it here where there's 25 acres even though there's 100 total because 25 is a substantial portion of 100 acres. Now, is the judge going to agree with you that 25 is substantial?
Probably not, but you never know.
All right, is it more than de minimis? Oh yeah, it's more than de minimis, right? Is it more than nominal? Y'all studied nominal damages in torts, right? The assault where you get a whole dollar? It's more than nominal. So is it substantial? Doesn't say it has to be most of it. It just says substantial, right?
Why don't they just survey it and not have the lawsuit?
All right, let's talk about why you would want to pick one district versus another.
Judge.
Not necessarily the judge. Where does the district get their jurors from?
Registered voters in the area where the court is.
In their area, right?
Your peers.
So let's talk about Jefferson County. There's an actual jury plan. Y'all got that website I gave you for the local rules? You go out to that same website not the local rules part, but there's a jury plan that tells how they're going to actually get all the jurors together in the federal courts. And as it turns out, they pull them together based on the division in which you file your action. So if I file something in the Northern District of Alabama for property that's in Shelby County, I'm going to get my jurors from Shelby, Jefferson, and I think Blount County. Now, if I file it in the Middle District, I'm probably going to get my jurors from Chilton, Elmore,
Montgomery, maybe?
huh? No, not Montgomery. Montgomery would be its own. No, I'm thinking, what's the other one? Watauga. I'm probably going to get them from Chilton, Elmore, and Watauga. Now, tell me about the differences between jurors who live in Chilton, Elmore, and Watauga County versus Shelby and Jefferson.
They're country folks.
They're country folks. So are they liable to be more generous when it comes to damages? It really does depend, right? So now you've got a strategic decision to make while you're still planning your lawsuit as to where do you want your jurors to come from. Yeah, Jefferson County is going to be strong Democrats, and so is Mobile. But the entire rest of the state is Republican.
So is Montgomery.
Montgomery did pull in mostly Democrats, though.
Really?
When you look at the election of Doug Jones, it was Mobile and Jefferson that got him elected. We're not going to get into political discussion. However, might that be a factor that you consider on where you're going to get your jurors from? Now, if you happen to have the jurors where you want to pull them from Hale and Greene County, and I can tell you about a case that came out of there. How many of y'all have heard of Jerry Beasley? All right, Jerry Beasley took on a case, and I think it was satellite TV, and this client of his spent approximately $600 to get satellite TV and didn't get very good reception. So he took him on and brought this big lawsuit, class action against the satellite TV provider, and for the $600 in damages, got a multi-million-dollar verdict.
Is he a product liability?
Yeah. Now, what's the first thing you see wrong with a multi-million-dollar verdict on a $600 damage? Excessive? Maybe violates Gore v. BMW?
That's not what they thought they were signing.
Yeah, it's not what they thought they were signing up for. So the stories I've heard about Jerry walking into the courtroom is he'll walk in and see the jurors and he'll ask them how each of their family members are. Hey Jimmy, how's your mama doing? Is she recovering from her arthritis? Now, that would be knowing your potential jurors, and might you want to pick a place where you know everybody in the county?
Yeah.
Maybe. And that's what federal courts are supposed to be designed to get around. Remember, first week of the semester, we talked about federal courts are there to make sure you get a fair jury trial. Remember that in your reading assignment?
Yeah.
Let's talk about just how fair the jury trials are in federal court. If you are suing in federal court in the Northern District of Alabama, Southern Division, you're getting your jurors from Shelby and Jefferson County. Jefferson County being much bigger, you're probably getting most of your jurors from Jefferson County. Now, what difference is that between suing in federal court in the Northern District, Southern Division, or suing in state court in Jefferson County?
You're definitely going to Jefferson County.
Well, you're definitely getting Jefferson County, but what else? Why were the federal courts created? To make sure you get a fair jury trial. And yet you're using the exact same jurors. Right? Folks, what they sold you was a lie. You're not getting better juries in federal court. You're getting the same jurors. The only thing different you're getting is a judge that's sitting there for life versus one that has to get elected every 6 years.
So you said there's multiple Northern District.
Yes, there's 7 different divisions inside the Northern District. And it's 28 U.S.C. Section 81, which defines all the districts in Alabama. And then the Northern District has 7 different divisions. There's the Southern, there's the Tuscaloosa, there's the Eastern, which is over in Anniston. There's a Jasper division, which encompasses the Jasper area. And what we're telling you here is you have to pick a district and division in which the property is situated, or a substantial portion of it. Or the other part, the first part of it is wherever a substantial part of the events or omissions giving rise to the cause of action occurred. Let's talk about car wrecks on the interstate. What if I've got somebody who blows past the barrier signs on 20 and goes into downtown and their car takes a dive off of the current interstate that they're building? Where did the events occur? Northern District if we're talking about federal court, Jefferson County if we're talking about state court. So all of the events occurred there. Where is the only venue which is proper in federal court if all the events occurred? It's going to be the Northern District, specifically the Southern Division, right? Now, let's use a different example. What if, and we've already talked about country folk, right? What if I've got 2 guys down in Chilton County that build a ramp and they're going to jump like James Bond in whatever movie that was where he did the corkscrew turn and landed on another ramp? Except we're going from Chilton County over to Shelby County. Now, he hits that ramp in Chilton County and he's flying in the air and an albatross flies into him. Causes them to miss the ramp and his buddy ends up critically injured. Where did the events occur?
Depending on where the car landed, if it landed in Shelby County.
Where did a substantial portion of the acts or events that gave rise to the cause of action occur?
Well, all the planning and building happened in
The accident.
Folks, would you believe you can argue probably either one, that a substantial portion was planned to take place in either county?
Yeah.
And therefore you may be able to argue Middle District, Federal Court, or Northern District. It's where these lines are drawn where you're going to have your arguments. But the rule says a substantial portion. Yeah, I'd probably still go with the Northern District. Well, if they build it in Chilton, maybe Chilton.
But if they landed in Shelby.
Or somewhere. The bird hit them somewhere and we don't know where it was. All right, the last test, part 3 of your test. Now remember, part 1 says if all the defendants reside in the same state. So the only way to get to part 2 is if you have defendants that reside in different states. That's the only way to get down to the next test. And that test is where the acts or omissions occurred or where the property is situated. Bless you. The third test is this: wherever you can get personal jurisdiction over a defendant. Wherever you can get personal jurisdiction over the defendant. It says specifically, if there is no district in which any action may otherwise be brought, in other words, Part 1 and Part 2 don't apply, as provided in this section, any judicial district in which any defendant is subject to the court's personal jurisdiction with respect to such action. So, quite simply, wherever you can get personal jurisdiction of the defendant. What's that?
My father was first two parts of the test, and that's all that's required.
Well, the problem is, the way the statute's worded, is that if one of those was property and you just go to number 3 by default, you filed it in an improper district and they dismiss your case. So there's the reason why. So you got to make sure that they're not in the same state and the acts or omissions of the property occurred outside the state. And so what are you arguing? either sufficient minimum contacts or where you can get them served, right?
So would it be an example of you're on 65 and you're a resident of Georgia? You're riding on 65, but they have a rental car and everybody in it is from whatever company you're, I don't know. One is from Michigan, one is from California. At that point, they get into an accident on I-65.
Okay.
Right?
And they're at fault? And they run into an Alabama resident?
You're from Georgia.
The plaintiff's from Georgia.
Yeah.
And they run into a car that's got people from all different states? Okay, where did the accident occur? On 65? In Alabama? Then that's going to hit number 2, where the acts occurred. You got it? Because you have defendants from different states as your first test. You pass that, but when you get down to where the events occurred, if it's 65 in Alabama, you're going to hit that. So you got to bring it in Alabama.
So what's an example? Sorry.
Number 3, if I am bringing a lawsuit against, let's say, a corporation who's incorporated under the laws of Delaware, but does business in Georgia. So they're residents of both places, and their employee who's a resident of South Carolina. And they get into a wreck outside of Chattanooga, in Chattanooga, Tennessee area. So I've got defendants from different states, so it would fall through the first one because they're not all in the same state. The accident occurred, so the act or omission occurred in Tennessee, but I want to sue them in Alabama because I know I can get them served here. Are they subject to personal jurisdiction if I can serve them here? Absolutely, right? So what if it's a delivery for the company and they're driving to drop stuff off down in Mobile, and I get them served, the company and the driver in Mobile? Have I got jurisdiction over them there? Or can I get jurisdiction if I know they're going to be there? Then I would pick to file it in the Southern District, knowing that I can get them served there, even though Tennessee, Delaware, Georgia, and South Carolina would all be proper. I know that I can get them here, so I would file it here and serve them here. Does that help? It falls through all 3 of those. And then bottom is where you can get personal jurisdiction over them.
Isn't the substantial event still in Tennessee?
The substantial event is, but I'm not filing it there. I'm filing it.
You kind of have a choice as long as you have the option.
Yeah, well, they're all from different states.
Yeah.
So you say, yeah, that was tricky. Yes, Ms. Cochran.
So this would really apply to if you had like an 18-wheeler truck driving accident that occurred in the United States. So you could.
Well, the first place you'd want to do it is file it where the accident occurred.
But would you, when you have those types of cases where you know it's a corporation and you're over $75,000, would you file it also in federal court? Or just depends on which court is more favorable to your...
Okay, let's look at that. I know I've got at least 4 bouncers in federal court, none of which exist in state court. Where do I want to file it? Well, I got less to overcome if I file it in state court, right?
Right.
Now the problem is, are they going to remove it to federal court once I file it there? They might. And we cover that next week, actually.
You still face those bouncers?
Yeah, you still face the bouncers, so you have to be careful. Yes, ma'am?
So with these examples that they're giving of like the car accidents and people from different states, if one of these individuals is injured and they're not able to, like if they're from Georgia or something and they can't come back to Alabama, like how does that work if they're not able to make it back to?
If you file the case here and they can't make it back here,
Right.
you take their deposition where they are.
Oh, okay, so they're not, like, it doesn't get moved just for them, they still have to stay here, period.
If you file it here, unless they get it transferred for more convenient,
Okay.
then it's probably going to stay here. All right, yes ma'am.
A question, the example that you were giving about serving the driver when he, for the corporation when he came into Alabama. Can you serve a driver? I thought you had to serve,
The driver's the same driver.
Oh, it's the same driver?
Same defendant,
Accident.
yeah.
Oh, okay,
That's the only reason I'm serving him.
okay.
And then also serve the corporation. But if you serve the corporation, where you can get him served, which is going to be Delaware, Georgia, right? Where they maintain their primary office or where they're incorporated. All right, if you got your federal rule book out, go ahead and turn with me to Rule 82. Rule 82 is easy and fast. What Rule 82 says, these rules do not extend or limit the jurisdiction of the district courts or the venue of actions in those courts. So these rules don't change subject matter or personal jurisdiction or venue. They just don't change it. So what they've done in the rules of civil procedure is said the venue statutes are there for a reason, and the rules don't change it. So 1390, your general rule of venue, those are the general rules. Now, I talked also about where there is a specific, it overrules a general. Here's an example one, just for an example. This one is venue for forfeitures. Y'all know what forfeitures are? For those of you who don't, it's where the law enforcement community comes in and takes away property away from a defendant because the property was either an instrumentality or a fruit of a crime. I got your attention. So if they go in and sell drugs to a bunch of people, and they have all those proceeds from drugs, and the federal government arrests somebody and says, these are all proceeds from the sale of drugs, they can file a lawsuit against that money and have it deemed forfeited to the government. That's what a forfeiture is. It says a civil proceeding for the forfeiture of property may be prosecuted in any district where such property is found. This is 1395B. This is just an example. Congress has actually gone in and said for a forfeiture case, venue is proper wherever you can find the forfeiture property. It doesn't matter where the defendants live. Venue is proper where the property is. Now, if I file a forfeiture action, am I going to use the forfeiture venue statute or am I going to use the general venue statute? I use the forfeiture, right? Because it's specific to forfeiture actions. If I file a forfeiture action, I use the forfeiture venue statute. However, if I'm filing a different case, like one to file an injunction against the defendant from stopping to sell any more drugs, is that a forfeiture? It's kind of general in nature, right? So I would use the general venue statute. I'd have to sue him where the defendant resides or where a substantial amount of the acts or occurrences take place, which would be where they sell drugs. But if it's just one defendant I'm suing, I'd get caught under that first test because that one defendant all lives in the same state. There's the example of specific what's wrong? All right. Now the change of venue. 1404. For the convenience of the parties and witnesses, in the interest of justice, which means the same thing as it meant before, whatever you can convince the judge of. A district court may transfer any civil action to any other district or division where it might have been brought, or to any district or division to which the parties have consented. 1404A. And then it also says under C, the district court may order any civil action to be tried at any place within the division in which it's pending. Now, y'all remember Larry Langford?
Yeah.
Remember he wanted to have his case tried in Tuscaloosa rather than Birmingham? Huh? Larry Langford? He used to be the mayor of Birmingham and the mayor of Fairfield. He was the mayor of Birmingham while he lived in Fairfield. And then he went to prison because he was on the county commission and they sold a bunch of worthless bonds for the sewer system. Yeah, he got a compassionate release and then he died shortly thereafter. But the short answer is he was a politician. And he was being brought up on charges related to his time in office. And instead of trying the case in Birmingham, he wanted it tried in Tuscaloosa. And the government agreed to that. 1404, they can change venue by agreement of the parties. And then the other one is for the convenience of the parties and the witnesses, they can move it to any other district in which it could have been brought to start with. Which means if I've got multiple different districts that I can pick from, remember our two defendants are Northern and Middle District divisions, that I get to pick either one. If I pick Northern, but all the witnesses and the parties are more convenient to Middle, under 1404A they can transfer it to Middle for the convenience of not only the parties but also the witnesses.
When you say they, you mean the courts?
The courts can transfer it for the convenience. And now there's another thing you need to know about venue, and it's called forum non-convenience. FORUM-NON-CONVENIENS. And yes, the last two words are Latin. Anybody want to guess what they mean? Inconvenient. Non-convenience is inconvenient. Now, under federal non-convenience, what the federal court does is they actually dismiss. Oh, you want the case? Leon versus Million Air. That's not millionaire as in a person, it's million, next word is air, Inc. M-I-L-L-I-O-N, million. As in 6 zeros. What forum nonconvenience is in federal court is more like an abstention doctrine. What they do is they dismiss it from federal court so you can file it in a more convenient forum. Now that's different from state forum nonconvenience. State forum nonconvenience, they actually transfer it to a venue within the same state. But federal forum nonconvenience is dismiss the case so that it can be brought somewhere else. And what they say, the summary of law for forum nonconvenience is you have to show three things. An adequate alternative forum is available. Well, as long as you have a federal and a state court system, aren't you always going to have an alternate forum which is available? Number two, public and private factors weigh in favor of dismissal. What's one of the public factors for dismissing a case in federal court? Colorado River. We don't want to use up our judicial resources, right? What are private factors? How about McGee? She needed a forum in which she could sue the insurance company, right? And then number 3, the plaintiff can reinstate his suit in the alternative form without undue inconvenience or prejudice. Well, they can reinstitute their case without inconvenience or prejudice. So, if the statute of limitations has not expired, can you argue that they can reinstate their case somewhere else without the statute of limitations having expired? Automatically, right? And then if you're the person that wants the case dismissed and brought somewhere else, can you argue that if you waive the argument of statute of limitations, then they can still bring it in another form? Absolutely. And you can do that as part of the maneuvering to get it from one court system to another.
Professor Bodie, what, is this a code, is this a section number?
No, this is the case I just gave out. Million Air versus Leon versus Million Air. That's the 3 things you have to show for forum nonconvenience. It's a judicially created doctrine, forum nonconvenience is. So you're going to find it in your case law. There's no code section for it.
But staying within the law, doing what's legal, subconsciously or subversively, you're trying to make it harder for them to participate in order to bring them to a settlement. Is that part of your strategy?
That may be part of your strategy, yes.
Okay.
All right. I did give you the specifics going to control the general. Here the Alabama Supreme Court says settled principles of statutory construction that special provisions relating to specific subjects are to control general provisions relating to general subjects, which again is what I told you earlier. And then here's a maxim. When the law descends to particulars, special provisions are to be interpreted as exceptions to general rules, which is the same way as saying specific overrules general. All right, now, this is our state stuff. We already know that under Stewart versus Rico that there's federal venue statutes and the federal controls in federal court. Well, since there are federal venue statutes, there are also state venue statutes. Now, the state of Alabama's venue statutes are a whole lot more complicated than federal, but you want to know what it boils down to? It's usually a 3-part test where the defendant resides, where the act or omission occurred or the property is situated, or wherever else you can get jurisdiction over the defendant. Does that sound surprisingly like the federal test? That's the general rule of venue in Alabama. Now, Alabama has got some other statutes you need to be aware of. First is 6-3-1. By the way, as we're getting into the state stuff, your notes, just take them down as your lecture notes, but don't turn these in as your summaries because this is for your practice and this is not for your bar test or your final exam here. So, for Alabama state law, any agreement or stipulation, verbal or written, whereby the venue prescribed in this article is proposed to be altered or changed so that actions may be commenced contrary to the provision of this article, well, they're void. Real simple. If you reach an agreement which is contrary to what the law is, Alabama legislature has already said that that agreement is void. So let's use an example. What if I've got a prenuptial agreement for a marriage that says we're going to, if this marriage falls apart, and either one of us wants to file for divorce, then we've got to file for divorce in Shelby County, Alabama. Everybody with me? And yet the couple spends their entire marriage together up in Scottsboro, Jackson County, where they separate. One of them goes to live in Huntsville and the other one goes to live in Decatur. And then somebody wants to file for divorce. Except there's this prenup agreement that says you can only file in Shelby County. I see a head shake over here. Ms. Grabinski's going, no. Then it is a contract, and the contract says it's got to be in Shelby County. 631 says that that's void. Because they agreed to have the suit only in a place where venue is different than what the law prescribes. For a divorce, venue is proper either where the separation occurred or where the defendant lives. And if they live in Huntsville or Decatur, and the separation occurred up in Scottsboro, Shelby County has nothing to do with that. And so the courts are going to hold that that venue provision is void. Now let's talk about something that gets a little bit closer to home. How about your attorney contract? And if your client ever sues you, you want to make sure that they sue you only in Montgomery County because that's where the state bar is located, even though your practice is going to be in Huntsville or Decatur. And your client is in Huntsville or Decatur. Nothing in your employment, they hire you to represent them on a car wreck case that happened in either Huntsville or Decatur. But you've got a provision in your contract that says you can only sue me in Montgomery. That's also going to be void because it's contrary to the venue statutes. Now, if it happens to be consistent with the venue statutes, they'll uphold it. But it really doesn't mean anything, right? Because if it's consistent with the statutes, then it was a waste of your time to go ahead and put it in your contract. Mr. Francis, you can come sit down.
So,
Oh, are you standing up there for your back, or are you just waiting to come back?
I just stretched.
Yes, ma'am.
I have a jurisdiction question that sort of arose.
Oh, this is venue.
Oh, okay. Never mind then.
Go ahead.
I'll ask you later.
Ask me after class. All right, so Alabama's venue statutes. If you look at Alabama Rule 82, it's a whole lot longer than Federal Rule 82 because it's got a section set out to clear up ambiguities. And that's because the Alabama statutes create some ambiguities. The first Alabama venue statute deals when you're suing an individual. When you're suing an individual for the recovery of land or the possession thereof, it has to be in the county where the land or a material part is located. What does that sound like? And these are actions of a legal proceeding against individuals. So they're not equity, these are legal actions. Where the land is located, number one. Does that sound like test number 2, federal? All actions on contracts, except as otherwise provided, commence to the county in which the defendant or one of the defendants resides. Sounds an awful lot like number 1 of federal. If such defendant has within the state of permanent residence. So wherever they live. Number 3, all other personal actions, which if it's not a contract and it's not about land, what's it going to be? Your car wrecks, any other tort, right? Or if the defendant or one of the defendants has within the state of permanent residence, may be commenced in the county of their residence, or in which the act or omission complained of may have been done or may have occurred. Sounds an awful lot like that same test in federal, right? In proceedings of an equitable nature. If the actions were real estate, where the property is located or a substantial portion thereof. And this is 632 if anybody's interested. If it's to enjoin proceedings or judgments of other courts in the county in which the judgment's entered, which is the location of your injury, right? Number 3, commenced in the county where the defendant or a material defendant resides. And number 4, in the county in which the claim or a portion thereof arose. In other words, the act or omission occurred. Now, because that one statute against individuals may create some ambiguities, Rule 82 has kind of a test that says if it's ambiguous, then resolve them as follows. I only point that out to you so you know that if there's an ambiguity, you go to the Rule 82 to figure out the resolution of the ambiguity. Now, the next code section, venue of actions for work or labor done, or breaches of easement or right-of-way contracts. Where do you think you sue for work done? How about where the work was done? Where do you sue for an easement? Where the easement is. How about actions against unincorporated groups issuing insurance policies? Yeah, we'll skip that one. Against unincorporated organizations or associations. Where they do business, right? So it's where the acts or omissions occur. How about actions for breach of an official bond? Who has official bonds? Probate judges? So if they fail to issue you a marriage license, you can take an action against their official bond. If marriage licenses are still being issued. Against foreign and domestic corporations, where the act occurred or where they have a residence. How about where you sue the prison system of the state of Alabama? They have a special venue statute. Yeah, where they're headquartered, which is Montgomery. How about actions against the county?
County seat.
The county. How about an action against the municipality? The county in which the municipality is located, right? So what about the city of Leeds? Where do you sue them? They are located in St. Clair, Jefferson, and Shelby County.
So you have a choice.
So you have a choice. You actually have a choice. How about, what's that one city up on Tennessee state line? Ardmore. Where do you sue Ardmore?
Either state.
Technically Ardmore, Tennessee is a different city than Ardmore, Alabama. Even though...
That's right. It's like Bristol, almost.
Yeah, it's kind of like Bristol, where it's Virginia and North Carolina. All right. They also have a provision for transfer of venue. Any party can ask for a transfer once, and that's 6320. Defendant in a civil action may move for transfer as provided by the Alabama Rules of Civil Procedure is 6321. Change of venue for the convenience of the parties or witnesses and in the interest of justice is 6321.1. So you know you have the same remedies in state court as you do in federal. Now the one that I skipped is 6-3-10. Y'all listen closely to this. In all counties having 2 courthouses, the provisions of this chapter shall not affect any local laws relating to venue in force at the adoption of this code. Well, the code was adopted back in 1975, right? So all the local laws that apply to courthouses, where there are 2 courthouses in a county, then all those laws are still good. And you have venue as prescribed by your local laws. Does anybody know where each county that has 2 courthouses? All right, let's start at the top. Barber County. has Eufaula and Clayton. There's 2 courthouses in that county. Jefferson is Birmingham and Bessemer. Somebody said Marshall, right? Albertville and Gunnersville. St. Clair has Asheville and Pell City. Anybody else? Tallapoosa County has Alexander City and Dadeville. Coffee County has Elba and Enterprise. Yeah, they're right next to each other. So is Albertville and Gunnersville. They're, that's not that far. Same road.
431.
All right, and there's one more county you need to know about, and that's Blount County, because they have a courthouse in Oneonta. But did you know they also had a courthouse in Bangor?
No, but you told us that's the
About the courthouse burned down? Yeah. So it's Bangor, but they spell it the same as Bangor, Maine. They pronounce it as Bangor. So, if anybody's interested in all the local ones, I have actually pulled all the general laws or local laws that create each of those different courthouses and case law that actually points out which one you do it from. Here's the important part you need to know, and that is St. Clair and Marshall counties, both of those counties draw their juries from throughout the entire county. But all these other ones that have 2 courthouses, they draw their jurors from only within the area for that courthouse. And while we're talking about venue, you need to know about where the juries come from. This is where they come from. Mostly it's going to be the county at large, except for those that have 2 courthouses, except for St. Clair and Marshall. And they also get theirs countywide. They weren't big enough back then. All right, there's one other thing I want to point out to you, and that is, in Alabama, can you file a case in a venue that you know is improper?
Yes.
You can file it.
You can file it, right?
Yeah.
So that was a trick question. Can you file it?
Yes.
Can you get in trouble with the bar for filing a case in a venue that you know is improper?
Depends.
I don't know, it depends. Yeah, they can.
With the bar, no, because who's gonna say what you know?
When you should, they got the pride.
Your
All right.
competency would never determine.
So the answer is no, you can't get in trouble for filing it in a venue that you know is improper. However, you can get in trouble with the bar for fighting to keep it in a place that you know is improper. And the Alabama State Bar actually issued an opinion on that. It's RO 89-117. And the question was, is it a violation of the Code of Professional Responsibility of the Alabama State Bar for a lawyer to file a lawsuit in one county when he knows the venue for that action does not lie in that county? And the answer to that question was, no, it's not proper to file it in an improper county, improper venue. However, if you want to fight to keep it in a venue you know is improper, that is because there's no basis of keeping that in that county.
It seems like some of this is subjective.
Not this one.
But you're arguing like, what's a substantial thing?
Now, if you've got an argument that is substantial, yes. But if you don't even have an argument that is substantial, that's where you absolutely get in trouble. All right, so recap. There are things you need to consider before you file your case. Venue is the last one out of a long list of them. Let's cover them real quick. Subject matter jurisdiction. You've got to know where the proper court is. Federal court is going to be federal question or diversity. And then supplemental for every other claim, like we covered last week. As many claims as you want to add, you can add as many as you want. As long as you've got your foot in the door for federal question or diversity. State court subject matter jurisdiction we talked about week 3. We're not going to test you on that, but you need to know it for your practice. What did we talk about the week after that? That was 2 and 3. Getting them into court. Getting them into court. You've got two parts to that. One is process and the other one is service of process. Process is the summons itself. It has two parts. Substantive, where the notice actually has to contain certain things, and then procedural. It has to be served by the proper person. Federal court is any person over 18 and not a party, or the U.S. Marshal, or a specially designated person, or who's the other one? No, who can serve them? Anybody else authorized under state law, right? Which then gets more complicated in Alabama. That's process. How about service process? If they're an individual, to them personally, to anybody who lives at their residence or usual place of abode who is of suitable age and discretion, or their agent, or any other person authorized by state law, right? So that's getting them in court. Keeping them in court, which was 2 weeks ago, that's our personal jurisdiction cases. That is, if they consent, voluntarily consent, waive, or voluntarily submit themselves. Consent, waive, consent, or voluntarily submit. That's the three. Or if they're served in the form. Number 3 is if they're a resident, regardless of where they're served. And then you have your specific personal jurisdiction, injury in the state, act in the state, and then action outside the state with injury inside the state, and that's Calder v. Jones. And the first one was Hess versus Pulowski, I think. That's the using the highways. And then if you don't have any of those 5, the last one is a desperate attempt at showing sufficient minimum contacts so that it does not offend, such that it does not offend traditional notions of fair play and substantial justice to require the non-resident defendant to come to the forum state to defend the action. That's your buzz phrase for that one. And paren, desperate attempt. That's keeping them in court. And then last week we covered all the pleadings and all the parties. You need to know all the pleadings in Rule 7A and all the names of the parties. But generally speaking, a plaintiff is one who causes the summons to issue, and a defendant is the one to whom the summons is issued. And then the plaintiff's going to file a complaint. Usually it's going to be a claim, but sometimes it can be a defense. And then the third type of pleading is a reply. So if the plaintiff sets forward a claim and serves the defendant, and the defendant decides I've got a claim against you, I'm going to go ahead and raise it now. That is a counterclaim when you raise a claim against the person who sued you. It's compulsory if it arises out of the same facts and occurrences, which are made basis of the plaintiff's complaint. And it's permissive if it does not arise out of the same transaction or occurrence. But you want to go ahead and raise it anyway. And then cross claims are claims against people who didn't sue you, but they are parties already. And if you've got a claim against somebody that's not a party, you become a third-party plaintiff because you're going to serve a summons and a third-party complaint on the third-party defendant.
Would we ever use the term impleader for third party?
You can say I'm impleading the following person.
Okay.
And then you set forward a third-party complaint. All right, and then remember when you talk about pleadings, that form I gave you last week, that you've got to have certain Rule 10 requires a whole bunch of crap.
Yeah.
Number 1, the name of the court. Number 2, the names of the parties. Number 3, the case number. And number 4, a designation under Rule 7A telling me whether or not it's a complaint, an answer, a cross-claim, counterclaim, or third-party complaint, or an answer to any of those, or a reply to any of those answers. And that's Rule 10. Rule 38, your jury demand. If you're going to demand a jury, you need to do it then or within 14 days of the pleading. That's also under Rule 38. Rule 11, your sanctions. You've read it. Number 1 is your certification. You're not interposing it for delay. There is substantiation, both legal and factual, behind what you're pleading, either under existing law or under a non-frivolous argument to change the law or to adopt a new law. It's got to be a sound argument for whatever reason you're asserting it. And then the last one is that there's evidentiary support for it. That sounds empty. You need more coffee. All right, so that was last week about setting forth claims, specifically ones upon which relief can be granted, noting the difference between federal and state court. Federal is plausibility pleading, where state court is still notice pleading. You have to, in federal court, put forward a claim that's plausible that you can recover. And if it's not, they're going to bounce it, and that's one of our bouncers. And you got to get them served within 90. I forgot to mention that. Back on. You got to get them served in 90 days. That's Rule 4M. And if you don't serve them in 90 days, they're going to bounce your case out again. And then this week our bouncer is venue, because if you can't pick the proper venue, you probably don't need to be filing complaints. And if you do, they're just going to throw it out anyway. Or transfer it to a more convenient form. Now, remember next week is the week you need to be here. Yes?
In federal, you said the possibility of serve within 90 days before that.
State's 120 days. But state won't automatically throw your case out. Federal, that's their mandate, just to throw it out.
And also possibility.
Plausibility versus notice in state. Conley v. Gibson is notice that Alabama adopted. All right, we're letting you out about an hour early. Y'all enjoy your lunch.
Nice change.
If y'all came in after I called roll, please come see me so I can get you on the roll.